we talked a little bit just before we started recording about the statute of limitation as well, and you talked there the length of time it takes for people to disclose, and I think I read somewhere it was 27 years, which is an awfully long time. Could you explain the statute of limitation bit for sort of for people out there, and perhaps where that's really getting it wrong as well?
So what the law says is if you bring a civil claim, and we're talking here about, when we talk about the statute of limitations, it's important to emphasize that we're talking about the civil cases here, it's claims for damages, claims for compensation. This doesn't apply to the criminal law. We don't have any time limits in terms of prosecuting sexual offences in the criminal law. But in terms of civil cases, the way that the law works basically is that if something happens to you when you're a child and you want to bring a claim for it, the time clock doesn't tick against you until you turn 18. But when you turn 18, the time clock starts ticking. And under the law, you have 3 years within which to bring the claim. And then once you get past that 3 years, it becomes much harder. And the reason that the law is designed like this is that the law was written back in 1980. It was designed for things like road traffic accidents or accidents at work, personal injury claims. It didn't, at that point in time, people weren't thinking about the difficulties that people who had been sexually abused or abused in, for example, residential schools, how long those people would take to disclose. So that wasn't factored into the law. And so we have this 3-year time limit. Now, it is possible to bring claims outside that time limit. It just becomes more difficult, and there are various things that the court has to look at. Various criteria, but the basic point is that we should not have that 3-year time limit. There shouldn't be a 3-year time limit, because we know from research evidence that it's actually very rare for people to come forward within that 3-year time limit. I've represented thousands of victims and survivors of abuse over the past 30 years. I think I can probably count on the fingers of one hand, maybe two at most, but probably one, the number of people I've represented who've actually come forward within that 3-year time window. Okay, so the norm is to take much longer over it. That's the norm, and we know that, and all the research evidence shows that, and there have been innumerable studies which have demonstrated that. So the 3-year time limit is wrong. It needs to go. And again, many other countries have got rid of it. In Scotland, which is legally a separate jurisdiction, they got rid of the 3-year time limit in 2017. In Canada, in America, in parts of America, in Australia, these time limits have been removed, and that's what we need to do here.
Yeah, thank you. And so you've touched on it a little bit, but where the law is helpful and where it's not in these cases, and we have this situation, of course, which you have touched on a little bit as well, with Scotland being different to England and Wales. So just for those that aren't aware of the kind of differences and where the law is helpful and not, would you mind just summarising that a little bit for us?
Okay, so to try and sort of summarize this very, very briefly. So in terms of law, this is in civil cases we're talking about. The law has made some strides forward over the past sort of couple of decades in terms of establishing that the institution has a legal responsibility to the victim. So we've had now for a few years something called vicarious liability, which means that if a perpetrator abuses a child, then the organisation that employs that perpetrator is potentially liable just because they employed that person. It's not always the case, but it often is the case. So we've got that concept of vicarious liability in the law, which was had to be fought for. Institutions resisted it, but we've got it kind of in principle there in the law. In terms of the time limit issue, we have the 3-year time limit. It is possible to get over that time limit in particular circumstances, which is all to do with whether you've got a justification for the delay and whether it's possible to have a fair trial, which is a kind of legal concept. What I would say to people is, if you if you are outside the 3-year time limit, you are normal. That's where most people are when they start thinking about the possibility of legal action. Speak to a specialist lawyer in this area and get some advice about whether it's going to be possible to go forward with it. Don't assume that it's not, because sometimes it's possible to get over that time limit hurdle. But I come back to the point that hurdle should not be there. We shouldn't be saying to people, 3 years is the kind of starting point for this, because it's not realistic, and it doesn't reflect the reality of what people have been through and everything we know about people's difficulties with disclosure, survivors' difficulties with disclosure. So we've got to get that change and move much closer to the system that they have, for example, in Scotland or in other parts of the world. I mean, across the Western world, there has been this recognition that these time limits are unfair and wrong, and we're lagging behind in England and Wales. We're lagging behind in bringing in that reform. I hope that sort of answers your question, but do let me know if you want me to sort of go into the technicalities a bit more.
No, it does, Richard. That's very clear, and I think the statute of limitation and mandatory reporting, you've made the need for those very, very clear. When it comes to civil cases, then the situation is different in Scotland than it is in England and Wales. I'm right in thinking, because of the redress scheme.
So that's another feature of the Scottish system. So obviously, civil cases have been are now easier in Scotland because of the change in the limitation law. They also have a redress scheme, although I think that the payments under that scheme can be quite modest, and I know it's been criticised. And one of the issues with redress schemes, and stop me if I'm going off point here, but I think this is actually quite an important point, is that ICSA recommended a redress scheme for England and Wales, and we do need something like that. But what ICSA didn't do was sort of suggest a mechanism by which institutions could contribute financially to that. Okay, so what that means is that if a redress scheme is set up, as things stand at the moment, if a redress scheme is set up in England and Wales, it will be funded by the taxpayer. So we as taxpayers will be paying for the failings of these institutions, and the failings of big organisations like the Catholic Church, the Church of England, big residential schools and so on. These institutions ought to be contributing to that. And I think the problem, if the state sets up a redress scheme, that's great, but you've got to look at how that's funded, because at the moment, there are so many pressures on the public purse. If we set up a redress scheme in England and Wales at the moment, and it's funded by the taxpayer, inevitably it will not be a very generous scheme. What we need to see is these institutions that have been responsible for these crimes and for this abuse actually contributing in significant financial ways to the funding of that scheme. And that, I think, would enable any scheme to be more generous. But I do think that's quite an important point, because if you just have state funding for a redress scheme, you end up generally with payments that are pretty modest.
Thank you very much, Richard. That's really clear. And I think, I wasn't of awareness of how it would be funded. I did think the institutions would automatically be involved in that scheme. So the fact it's falling on the taxpayer, which, as we know, things are very difficult at the moment. It also might help.
Interesting. So I was just going to say, it's interesting that you make that assumption, because I think most people would make that assumption, but there was nothing in the ICSA report. I was surprised, actually, but there was nothing in the ICSA report to say, look, here's a mechanism by which these institutions can be forced to contribute. So I think there was a talk about maybe they could, be invited to make voluntary contributions. Well, that's not going to get us very far.